Here's our chance to look at another difficult remedies problem. At least this one has a lot of calls of the question. Typically that will make it a little easier than the more obscure, vague calls. Take a look. Call number 1. How should the trial court rule on the merits of Peter's action? Discuss. Well, we can't even outline this one yet. We've got to identify what his theory of liability is. 2. If the trial court issues a mandatory injunction requiring Debbie to have the porch removed within 30 days, but Debbie does not comply, what procedural steps should Peter take to make her comply, and what should be the result? Discuss. Well, we don't know whether or not this defendant should be forced to comply, but we do know how a plaintiff in this situation should continue. The approach would be to have a motion for a hearing with regard to contempt to get the court to enforce more strongly its previous order. Question 3. If the trial court concluded that Debbie willfully disobeyed the injunction and fines her $1,000, but on Debbie's appeal, the appellate court concluded that the injunction should not have issued, how should the appellate court rule on whether Debbie must pay the $1,000 fine? Discuss. Well, we don't need to read the fact pattern to be able to answer this question completely. If this defendant failed to request a stay of enforcement pending appeal, she's going to be on the hook, and the reason for that is a comparatively obscure but fairly commonly tested bit of law known as the collateral bar rule. The collateral bar rule bars a party from ignoring a lawful court order. That party has got to either obey the order or find some way to get a stay of enforcement of the order pending an appeal. You can't just ignore a lawful court order, and when you do, you can expect to be sanctioned. Now, we notice that call of the question number 3 implies part of the answer to the second call of the question. So far, the first call of the question is insufficiently precise to allow us to really assess it. But the second and third calls of the question really refer to one another, and they're both short answer questions. Then, question 4. If Peter had not commenced his action until 1 year after his discovery of the encroachment, and Debbie had moved to dismiss the action because of this delay, how should the trial court rule? Discuss. Again, we're going to have a look at the facts before we can really venture a clear answer to question 4, but again, it seems quite evident that this is another short answer question. So it looks to us, just by looking at the calls of the question, that the first call of the question is the most difficult and the most challenging one. Questions 2, 3, and 4 are all short answer questions, and we can tell that before we've even read the facts. Now we glance up, we see that this is a very short 3-paragraph fact pattern. Typically, the shorter the question, the more difficult the essay. Facts like this readily could be present on any form of multi-state question. These facts are shorter than many MBE questions. So, let's take a look. In paragraph 1, we meet our defendant, Debbie. She has bought an oceanfront vacation house on lot 1. Right after that, Peter buys an oceanfront house on adjoining lot 2. The houses are comparable in size, value, and age. Now look at paragraph 2 and see what this plaintiff does. After his purchase, Peter hires a surveyor to lay out the boundaries of lot 2, and the surveyor reports that part of Debbie's porch is encroaching on Peter's property. In particular, the 10-foot wide porch extends 7 feet laterally onto Peter's property. But now look at the next crucial fact. The encroachment was made by the original developer 25 years before Debbie and Peter bought their properties. So let's just pause for a moment. Excuse me for waxing like a defense lawyer again, but do you have the impression that I have about this plaintiff? That he's trying to get more than he actually bargained for and paid for? How come he didn't have these boundaries surveyed before closing? Why is he doing it so late? And looking at the fact that the properties have had this configuration for 25 years, doesn't it seem that this plaintiff is overreaching a little bit? Well, let's go to paragraph 3. 6 months after learning of the encroachment, Peter commences an action to compel Debbie to remove the porch from his property. And then we get the cause of the question again. And as anticipated, it's our answer to the first question that's the most difficult, and that requires us to do the most careful thinking and organizing. So turn the page and take a look at the outline of issues that I've presented. We are asked about the merits of Peter's action, and his action is really grounded in the law of real property. And so his theory of liability is an encroachment, and there's not a whole lot to say about it. We are told that the porch goes 7 feet beyond the property line onto Peter's land. So he can establish the encroachment easily, and there are no factual defenses to the encroachment. The property clearly has got the porch extending beyond the property line. But Debbie does have a valid defense against the plaintiff's action based on adverse possession. Now, perhaps you'd say, wait a minute, these parties have only been on this land for a few months. How can a plaintiff or defendant who has just bought her land assert adverse possession as a defense? Well, when you think about it, the prior owners of this property already had title to that part of Peter's land that the encroachment is on as a result of adverse possession. Let's consider the basics of adverse possession. If you wanted to go into a full Hornbook analysis, I would encourage you to do so. But the essence of adverse possession boils down to a mental element, a physical element, and a time element. Did the prior parties in interest treat this land as if the border was where the porch was? Answer, yes. Did the prior owner of Debbie's parcel occupy that stretch of land with hostile intent? Answer, yes. It was occupied under color of title, belief in ownership. Was the land physically occupied? Again, answer yes, continually by all of the prior owners for the 25 years that the properties have been next to each other. 25 years is enough to satisfy the time element in any jurisdiction. So I think that Debbie has got a valid and in fact a winning defense to the plaintiff's theory of liability. The plaintiff's theory of liability is encroachment. The defendant's defense is the prior adverse possession of her predecessor in interest. I say it's a winner, but that doesn't stop me from going on to consider remedies. The plaintiff here would argue that damages are inadequate, and given that this is a dispute involving real property, that would be true. Still, it would be possible to calculate what the damages suffered by the plaintiff would be based on the value of the property. Here, a restitutionary theory almost makes a little bit of sense also, requiring the defendant to pay the extra value that the encroached land adds to the property. But what the plaintiff really wants here is a mandatory injunction. And in fact, the trial court agreed that the plaintiff should be entitled to it. So we consider all of the elements of injunctive relief. Are damages adequate? No. The dispute involves real property ownership. All land is unique. The plaintiff has got a right to equitable relief because damages are inadequate in this situation. Is there a property right involved? Yes, it's really impossible to think of a situation that is a more explicit presentation of a property right at issue. We've got adjoining landholders having a dispute over encroachment. You can't get more property-like than that. Would it be feasible for the court to enforce an equitable remedy? Yes. The court has in personam jurisdiction over the parties, in rem jurisdiction over the parcels. Balancing the hardships is where the plaintiff would have his most difficult trouble. Because even if we stipulate for a moment that the defendant's adverse possession claim fails, it still seems as if this plaintiff is coming to court with unclean hands. And the reason I say that is because of the timing of the case. I think this plaintiff should have had this inspection done before closing. I think that his actions are tainted by bad faith. He already bought and paid for this land. His neighbor bought and paid for her land. He could have investigated this issue before he bought the parcel, and he didn't. And I think that would be enough right there to deny him equitable relief and to limit him to a damages remedy, if that. Ultimately, I find in favor of the defendant. I think that the plaintiff's claim is essentially bogus because of the prior adverse possession of this parcel, of this strip of land, by the predecessor in interest. So I conclude in favor of the defendant. Now, the other questions presented here are short answer questions, and they're comparatively easy if you know the law. And once again, we're doing this practice to learn law, not just to learn technique. So, how does a plaintiff in Peter's position, having prevailed at trial, enforce the result? He's got to file an order to show cause motion, go for a contempt citation. The only defense that the defendant could offer would be that a good faith appeal is underway. She should have stayed enforcement seeking that appeal, but the result is she should be sanctioned if she doesn't seek a stay. Next, we turn to the fine. Here, the collateral bar rule, as I discussed right up front, is really all we need to know. This defendant was subject to a lawful court order. She ignored it. She's liable. Finally, Debbie's motion to dismiss. The issue would be laches. This case would be no more ripe in 6 months, but I already find that the plaintiff really shouldn't be bringing this action in the first place. If the statute of limitations hasn't told, an extra 6 months would not destroy the plaintiff's claim. So I don't think Debbie's motion to dismiss is strong, but I do think her defense is strong.